All right. I want to take this opportunity to welcome everybody to this public meeting of the Standing Committee of Economic Development and Environment. This is our clause-by-clause review of Bill 25, an act to amend the Workers' Compensation Act. And I'd like to get us started with a prayer, and I'll ask Mr. McNeely to lead us in a prayer. Thank you.
Thank you, dear Lord. Watch over our family as we deliberate in the better interest of our homeland and the people that we serve, and be mindful of the help that is needed by the unfortunate ones. Masi.
Amen. Thank you, Mr. McNeely. I'll take this opportunity to have members introduce themselves for the record, and I'll start on my far left.
Hi, good evening. Welcome. 7 o'clock Friday night. Herb Nakamak from the Nukput.
Kieran Tester, member for Kamloops. Good evening.
Danny McNeely, Satu. Good evening.
Kevin O'Reilly, Frame Lake.
And I'm Corey Vanthline, MLA for Yellowknife North and the chair of the Standing Committee on Economic Development and Environment. We also have with us here this evening our law clerk, Sheila McPherson, from our research department, April Taylor, and our committee clerk, Michael Ball. And so, where are we? Just one moment. Today, the Standing Committee on Economic Development and Environment is holding a public clause-by-clause review of Bill 25, an act to amend the Workers' Compensation Act. Bill 25, an act to amend the Workers' Compensation Act, proposes to change the existing legislation to clarify the terms impairment and disability, add detail respecting who is considered an employer within the scope of the act, clarify the compensation paid to dependent children of a deceased worker, remove the requirement for a primary health care provider, add unemployment as a category of remuneration, authorize information sharing and disclosure for the purpose of improving the administration of the Act, enable an inspector to inspect health care providers' records, and correct inconsistencies and errors identified in the Act. I would like to take this opportunity to point out the unique nature of Bill 25. The shared nature of the Workers' Safety and Compensation Commission between two jurisdictions, the Northwest Territories and Nunavut, gives rise to a unique situation. Two distinct and sovereign legislatures are concurrently considering amendments to two pieces of mirrored legislation to govern a single body that conducts business in both jurisdictions. This means that at the same time that we are considering Bill 25, our counterpart in Nunavut, the Legislative Assembly of Nunavut Standing Committee on Legislation, will be considering Bill 8, which largely mirrors the provisions of Bill 25. While the circumstances that have given rise to two different legislatures in two independently governed jurisdictions considering mirrored legislation are unusual, they are not without precedent. The most recent time this situation occurred was in 2018, when both the Nunavut and the Northwest Territories considered establishing the Chartered Professional Accountants Act. And prior to it, in 2015, when both territories considered review of the Northern Employee Benefits Services Pension Plan Act. It was 2007 when both Nunavut and the Northwest Territories considered a new Workers' Compensation Act. Passage of this act allowed both jurisdictions to continue to share a single Workers' Safety and Compensation Commission. Bill 25 received second reading in the Legislative Assembly on October 29th, 2019, and was referred to the Standing Committee on Economic Development and Environment for review. On February 26, 2019, the committee was granted an extension to continue its review. The committee sent letters inviting input from an extensive list of stakeholders, including municipal and Indigenous governments in the Northwest Territories, as well as a number of non-governmental organizations and stakeholders. A public hearing was held here in Yellowknife on February 12, 2019. Committee thanks everyone who attended the public hearing or provided written submissions sharing their views on Bill 25. There are copies of the bill available at the back of the room, and I will now invite the Honourable Alfred Moses, Minister responsible for the Workers' Safety and Compensation Commission, to introduce yourself and your staff for the record and proceed with any opening remarks you may have. Minister Moses.
Thank you, Mr. Chair. Mr. Chair, and thank you to committee. I am pleased to be here today, and I wish to thank the members of this committee for your consideration of Bill 25, an act to amend the Workers' Compensation Act. With me today, I have Ms. Kim Collins-Riffle, Vice President, Stakeholder Services and Acting President of the Workers' Safety and Compensation Commission to my immediate left. Mr. Matthew Kossier, Manager of Policy and ATIP Coordinator, and Christina Brownlee, the Legislative Counsel with Justice on my far left, as well as Ms. Ronna Sherigan, my Ministerial Advisor. Mr. Chair, we feel that the amendments strike a balance between privacy and confidentiality of health information, modernizes the language for clarity and transparency, and aids the Commission to ensure the sustainability of the Workers' Protection Fund. This bill amends the Workers' Compensation Act to do the following: clarify the usage of the terms impairment and disability, add detail respecting who is considered an employer within the scope of the Act, remove the requirement for a primary health care provider, clarify the compensation paid to dependent child of a deceased worker, and also maintenance enforcement garnishment. Add EI benefits as a category for remuneration, authorize information sharing and disclosure for the purpose of improving the administration of the Act, enable an inspector to inspect healthcare providers' accounting records to verify services received and correct inconsistencies and errors identified in the Act. Mr. Chair, these amendments in Bill 25 and motions that are considered today will ensure certain provisions are in compliance with past court decisions, improve operational efficiencies in the WSCC, and clarify language with clear information and interpretation. This concludes my opening remarks, Mr. Chair. I do look forward to hearing any comments, questions, and answering any questions that the committee may have. I wish to thank the committee for your comments, and I do believe there's going to be motions today, and we will look forward today. On another note, Mr. Chair, I do appreciate that committee and the government has acknowledged that with this piece of legislation, we are doing a cross-jurisdictional with Nunavut, and I do appreciate the Chair's opening comments that we did acknowledge and recognize that before we go into the clause-by-clause review. So, thank you.
Thank you. Thank you, Minister Moses. This time I'll turn it over to committee. Does committee have any general comments or questions before we begin the clause-by-clause review? I'll start with Mr. Testart.
Thank you. Thank you, Mr. Chair. So I have my general comments will cover kind of two grounds. One is the overall nature of the legislative scheme that exists that governs the WSCC in both jurisdictions. And the second will be the balance of privacy with efficiencies that has been struck in these amendments. On the general nature of the commission, I find the hybrid or the dual nature of the mirrored legislation difficult to work with as a legislator in this government, and we sought that. The chair mentioned seeking an extension early on, and that was largely because our counterparts in Nunavut had some serious concerns that couldn't move forward, so that delayed our process. And for a while, there was a concern that one of these sets of amendments would be in place before the other one, so you'd have two different sets of rules in two different jurisdictions. There's also the kind of trans-boundary nature of the commission when it came to establishing the new chartered accountancies professional. It was actually the bill that was in place, although it had the support of the Nunavut government. It was actually unconstitutional to do so with one bill. So that's not the case for the WSCC, but these ongoing issues, I think, are going to continue to challenge the legislative structure that underpins the commission. And I say this as well as a member who represents a riding of many business owners who have their own thoughts and concerns about the operations of the WSCC and ideas for improvements and efficiencies. And if you did have members come forward who wanted to act on the views and aspirations of their constituents to improve, and Nunavut said no, then you'd be in a very difficult situation where you'd have duly elected MLAs pushing for changes on the NWT side and being told they can't because you wouldn't want two systems. So I think this is something we really need to figure out, because on the one hand, I acknowledge that the fiscal realities of the commission make more sense when you can cover the two territories. But the governance issues are, I think, crucial, again, in being able to pass laws and regulations for your own people. And we're going to have to come to a conclusion on how we want this to run. And I would encourage both the commission and the government to think about that and think about how ways we can do that we could have a commission that has some sort of formal sharing of resources, so it can so rates won't dramatically increase for business owners and people who have to pay those rates. But also that allows the flexibility of each jurisdiction to set its own framework. So I can leave that comment alone and move on, or if the minister wants to respond, I certainly can.
Thank you. We'll take that as a comment. Any reply to the comment? Minister Moses?
No, I agree. I sat on that side of the table when we were going through NEBS, and there has to be a process in place, especially when we're working with another jurisdiction to do a legislation that's going to impact businesses, employers, employees, such as this one, or something like we did with NEBS in the 17th Legislative Assembly. And I think as we are going into a new election, that's something that might need to be put into the transition documents, that there's got to be a better process when we're creating this type of legislation and work moving forward. So I take the members' comments and we'll make sure that our staff understands this and other pieces of legislation that we have with Nunavut for the next government coming through.
Thank you, Minister. Further, Mr. Testart.
Thank you, Minister, and thank you to your staff. I see noddings of heads, and that's appreciated. The second issue is you said in your opening comments that you feel that these amendments strike the balance between privacy and modern and making the commission more efficient and being able to deal with. And I think I'm of a difference of opinion. And tonight, though, the committee will bring forward some motions to address those concerns. But and I'm glad we were able to come to. We've been. The public doesn't have the benefit of some of those discussions and meetings. They'll see the results of those work tonight. But I think it's really important that we all have a good understanding of what our obligations are under ATIP, what our obligations are under protecting the privacy of individuals, in addition to ensuring the government can do its job. And again, the amendments that will be brought forward will strike a better balance for that. But it's crucially important going forward. All of our agencies, our laws, all of that stuff puts a high priority on personal privacy and enshrines that in everything we do, and that privacy assessments are brought forward with legislative proposals. I don't think that was the case here initially. Some work has been done there, but we could have avoided a lot of the, I think, consternation on the committee's end and on our counterparts as well. This isn't just this committee, but also our counterparts in Nunavut, if those proactive measures had been taken, if proper assessments had been done, and if we were able to see the results of those assessments when considering the legislation. So, and some of us on this committee had the benefit of working on the ATIP legislation, so we have more expertise in this area. Not every member is going to be in the same boat going forward, so it's really important that the government and the WSCC does that moving forward. Thank you.
Thank you. Take that as a comment to the comment. Minister Moses?
Yeah, thank you, Mr. Chair, and we do appreciate the comment. And I think over the last couple of days here, we did work on trying to work with staff from committee and committee members and our staff to see how we can address this. One concern of mine is that some of the other elected officials in Nunavut have not seen some of these motions, and where we are, as I told the chair earlier today, that we are willing to work with committee to address these now, and we'll see as we are in a transition going into a new government, and I do believe Nunavut's going to be sitting in October, but we will. I know the staff and the law clerk staff and our staff have been working with our counterparts to address these, but I do take the comments, and I think that as elected officials, whether Nunavut or here in the NOT, we all got to work together to make sure that we have the best possible piece of legislation moving forward. Thank you.
Thank you, Minister Moses. Next, I have Mr. O'Reilly.
Thanks, Mr. Chair. I'll keep my comments short because it's been a long day for some of us. I want to first say that there's some talk about balance in the minister's opening remarks. The part that I didn't hear a lot about was workers' rights, and that's the lens that I'm going to bring to this legislation is, I've never been a member of a trade union, but I believe that they have resulted in many of the benefits that we enjoy. The weekend that we're all about to enter into and not having to work part of that weekend maybe. So that's a lens that I brought to this legislation was the rights of workers and making sure that that figures into the equation. So I guess the other thing I want to say is that I want to encourage the minister and the people at the Compensation Commission to use the Information and Privacy Commissioner. She's there available to provide assistance and advice on some of these matters. And some of the motions that I think you're going to see tonight spring from the advice that she gave us as a committee. But you folks also have the ability to access her advice in drafting the legislation and even conceptualizing it before it comes here. And I think that might have made for a little bit smoother ride. Not that this was a big bumpy ride, but I want to suggest that you do avail yourself of that. The last thing I guess I want to say, Mr. Chair, is that I really do appreciate the work that our staff and your staff have done to address the significant concerns that we had with this bill. This is, what do I know about this stuff? But the concerns were raised with us, and I really want to compliment the minister, the staff with the commission, and our staff in finding solutions to the issues that we've raised. And I think we've come to a good landing on where we're going to get tonight. So thanks very much.
Thank you. Take that as a comment. Any reply to the comment?
Yeah, no,
Minister Moses.
Yeah, thank you, Mr. Chair. No, I agree with the member. Workers' rights is very important, and appreciate the comments that our staff and your staff came together to work on getting this piece of legislation the best that we can and letting Nunavut see what we're doing. We have been keeping them informed of what we are doing in terms of the amendments and the motions that were brought forward. And any comments that come out of committee tonight, our staff's taking notes, and we'll make sure that as Nunavut goes into their session coming up in October, that they'll know that the discussions that we had here tonight. So I appreciate the members' comments. Thank you.
Thank you, Minister Moses. Any further comments from committee? Mr. Nakamaiak.
Yeah, thank you, Mr. Chair. Thank you. Thanks to the minister and the staff for all their hard work. My only concerns, I know I'm not going to drag this on any further, but I'm just wondering, when will this come into force? And, coming from this meeting and coming from the clause by clause, I'm wondering what kind of negative impacts it may have to our neighbors in Nunavut. Maybe a good time to practice our government-to-government relations and really make this more effective. As they are going into session only in October, and I don't know if we're pushing this or rushing things. It seems like we want to hold title to a lot of this stuff, but I think some things like this, when we look at the big picture, it makes sense to maybe to collaborate more when both governments are in session. I think that's maybe looking forward. It might be a learning lesson, something we can all learn from together on this. And those are just my concerns, basically. Thank you, Mr. Chair.
Thank you. Take that as a comment. To the comment, Minister Moses.
Yeah, thank you, Mr. Chair, and appreciate the comment. As I mentioned earlier to Mr. Tessart's comments there, I think there's got to be a better process in place when we're doing cross-jurisdictional pieces of legislation. I think that's something that we will reiterate with Nunavut when we pass our bill here, do the clause-by-clause review, and before our government's done, that it's something that we need to have a serious discussion about, because it really reflects our employees, our employers here in the Northwest Territories, when we're not sure what's going to happen in Nunavut or if things might change. I can't speak on their behalf, but what we got here tonight, I think, is the best piece of legislation that we can pass through and give them the information. But I do agree that there's got to be a better process moving forward with our legislative staff and our departments on any cross-jurisdictional pieces of legislation moving forward. So appreciate those comments. The coming into fourth state is something that we'll have to see how Nunavut works on their bill that reflects our Bill 25. Thank you.
Thank you, Minister Moses. Any further comments from committee? Seeing none, small suggestion from me, from what it's worth, would probably be when you have cross-jurisdictional legislation that you move it into year 2 or 3 to start the process, rather than leaving it to year 4, much less the latter part of year 4. So that would be helpful. That said, does committee agree to conduct a clause-by-clause review of Bill 25, an act to amend the Workers' Compensation Act? Agreed. Thank you. We will defer the title of the bill until the end and begin with consideration of the clauses. There are 38 clauses in the bill. Where possible, we will group the clauses. So please turn to page 1 of the bill. Clauses 1 through 5. Does committee agree? Thank you. Clauses 6 through 10. Does committee agree? Thank you. Clauses 11 through 13. Does committee agree? Thank you. Clause 14. Does committee agree? No.
Sorry.
Clause,
Mr. Chair.
one moment, please. One moment. To clause 14, does committee agree?
Nay.
Okay. Mr. Testart.
Thank you, Mr. Chair. Just to explain this, because it's not our normal practice, but or not typical in the proceedings of committees in a consensus government. Typically, changes to bills are brought forward by amendment, but in this case, this clause was found to be particularly problematic by the committee by offering powers to the commission that were intrusive on the personal privacy of health information possessed by workers who were in a process where they're claiming benefits from the commission. So the committee feels that this clause needs to go, and the rest of the bill will be intact, and there'll still be an ability for the commission to access these records, but it strikes a better balance for the personal privacy of health information. So as a result, I encourage the committee to vote against this clause. Thank you.
Any further comments? Mr. O'Reilly.
Yeah, thanks, Mr. Chair. Sorry for the slip-up earlier. This is a clause that would allow the commission to not just get reports of medical treatment, but to actually obtain actual medical records, which is really not necessary. And this issue was brought to our attention. I want to give the Information and Privacy Commissioner credit for highlighting this issue for us. And I'm sure that the Commission will be able to continue to operate and do its due diligence without access to the actual medical records. They can ask for reports, as they can and should. So this is not necessary, and I'm glad that the minister was able to work with the committee and that we can all agree that this is not necessary and that we're going to delete it from the bill. Thanks, Mr. Chair.
All right, thank you. Any further comments? To clause 14, committee agree?
Nay.
Nay. Committee does not agree with clause 14. As chair, I will seek ministerial concurrence to remove this clause from Bill 14. Does the minister concur with removing clause 14 from the bill?
Thank you, Mr. Chair, and yes, I do concur with the motion that was put forward. Also, just want to make a point out that our counterparts in Nunavut have not seen this, the committee, but we will be taking notes and ensure that committee in Nunavut, the elected members, will get all this information so that they can make a informed decision as well. But we do concur. Thank you.
Thank you. The minister concurs. Thank you, Minister. Committee, Clause 14 will be deleted. Next, Clauses 15 to 20, Committee agree? Thank you. Clauses 21 to 25, Committee agree? Thank you. Clauses 25 to 30, does Committee agree? Thank you. Clauses 30 to 32, Committee agree? Thank you. Clause 33, Mr. O'Reilly.
Thanks, Mr. Chair. I move that Clause 33 of Bill 25 be amended by A, renumbering proposed Clause 95 as proposed subclause 95 brackets 1, and B, adding the following after that proposed numbered subclause brackets 2, notwithstanding subsection 1, the Commission shall not permit direct access by an entity other than the Commission to databases containing information obtained by the Commission under this Act. Thanks, Mr. Chair.
Thank you. The motion is in order to the motion. Mr. O'Reilly.
Thanks, Mr. Chair. As the Minister said in his opening remarks, part of this bill is to give the Commission the authority to enter into agreements with other governments, including Indigenous governments, boards, commissions, agencies, to share information and allow for better administration of our workers' rights and compensation and so on. So the bill enables that in Clause 33, but concern was raised with this committee in a submission by the Information and Privacy Commissioner that these other agencies or bodies that the Commission enters into agreements with should not have unfettered access to the databases themselves, that only the Commission should be able to access the information contained in the databases. The Commission, though, can be in a position to extract information and share it, and that would be a purposeful sharing of information. So the purpose of this is to say that any information shared is through the Commission itself, not by a third party directly accessing the databases. So I think it provides a measure of protection of privacy for workers whose information is stored and so on, and puts the responsibility really on the Commission itself. So I think this is a useful amendment, and I want to thank the Information Privacy Commissioner for bringing this to our attention. Thanks, Mr. Chair.
Thank you. Further to the motion? If there's nobody further to the motion, I just would also like to note for the record at this time too that this was a motion that was concerning to our colleagues in Nunavut, and that they too were pleased to see that this would be coming forward. And so is there any other comments further to the motion? To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Mr. Chair, and yes, I do concur with the motion. Thank you.
Okay, thank you. The minister concurs with this amendment. Thank you, Minister. Committee to Clause 33 as amended. Does committee agree? Okay, thank you, committee. Clause 34. Mr. Testart.
Thank you, Mr. Chair. This clause of the bill amends the provision for appeal from 2 years, or sorry, from 3 years to 2 years, and the committee felt that that was not an appropriate amount of time, given the often vast geographical distances that workers in our communities have to live in, the challenging nature of telecommunications, et cetera, that a 3-year term would be a more appropriate time period. And as a result, committee feels that this section should be, this clause should be removed from the bill, and I will be voting against it. Thank you.
Further comments? Mr. O'Reilly.
Yeah, thanks, Mr. Chair. Yeah, we did discuss this as a committee and felt that the Commission did, through the Minister, did provide some information about the number of appeals that had been filed and the period of time in which they had been filed and so on. And I guess what we did find out that if the period had been cut back to 2 years, it would have resulted in maybe half the number of appeals that had been filed. Of course, the Appeals Tribunal still has the ability to accept appeals beyond the 2-year limit, but I guess the committee was of the view that this was not necessarily in the interest of workers, so we agreed that we would suggest that this be deleted, and I'm glad, I understand that the minister is prepared to accept that, and I think it's a good compromise in the interest of workers' rights. Thanks, Mr. Chair.
Thank you. Further comments? No further comments to Clause 34. Does the committee agree?
Nay.
Thank you. Committee does not agree with Clause 34. As chair, I will seek ministerial concurrence to remove this clause from the bill. Does the minister concur with removing Clause 34 from the bill?
Yeah, thank you, Mr. Chair, and yes, I do concur. And as I mentioned in earlier comments, we'll keep our counterparts apprised of comments and discussions that arise from deleting this, so that they're prepared for when they do their clause-by-clause review. Thank you.
All right, the minister concurs. Thank you, Minister. Committee, Clause 34 will be deleted. Clause 35, Mr. Nakamayak.
Thank you, Mr. Chair. I move that Clause 35 of Bill 25 be deleted and the following substituted. 35, subsection 134 brackets 1 is amended by striking out "for the purpose of ensuring compliance with any provision of this Act" and substituting subject to Section 134.1 "for the purpose of ensuring compliance with any provision of this Act." Thank you, Mr. Chair.
Thank you. The motion is in order. To the motion?
Question.
I'll start with Mr. O'Reilly.
Yeah, thanks, Mr. Chair. So in the bill, Section 35 provides for the authority of an inspector to basically enter into a healthcare facility and search through and audit records related to medical treatment received by a worker who submitted a claim. And I guess it was the view of committee that this was overreach, that this was probably too intrusive. And once again, I do want to give this credit to the Information and Privacy Commissioner for providing her input on this aspect as well. And in discussion with between our staff and the commission and the minister's staff, it was understood that the real purpose for reviewing these medical records was to ensure that the workers were getting the treatment as they commit to and as part of their program, and that the services were being properly billed and so on. So what we did, we came to an understanding that that was really the purpose for accessing the medical records of a facility, not to understand what the claimant was, the basis for the claim and all of that kind of stuff. That's a different process. So this is really just to make sure that the treatment that's offered is actually taken and is billed for properly. So on that understanding, I think we've come up with an amendment, a couple of amendments that everybody can live with and agree to. And I once again want to thank the Minister, the Commission staff for reaching this agreement, and our staff for bringing this forward as well. So thanks, Mr. Chair.
Thank you. To the motion? Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Mr. Chair, and appreciate the comments from members. And I know that I won't say it was at the 11th hour, but our staff worked together to come up with a good compromise. As I mentioned, and I'll say it again, is that our counterparts in Nunavut have not reviewed the new clause. But we, as I said earlier, will ensure that the information and the reasoning behind why we concur with the motion, we'll share with our counterparts so that they're prepared when they do their clause-by-clause review, as well as taking comments and concerns from members from standing committees. So with that, we do concur on this motion. Thank you.
Okay, thank you. The minister concurs with the amendment. Thank you, Minister. Committee to Clause 35 as amended. Does committee agree? Thank you. Clauses 36 to 38, committee agree? And, oh, sorry, Mr. Testart.
Mr. Chair, I move that Bill 25 be amended by adding the following after Clause 35. 35.1, the following is added after Section 134. 134.1 brackets 1, notwithstanding Section 134, an inspector may only enter and inspect any healthcare facility in accordance with this section. 2, an inspector and any person assisting the inspector may, at any reasonable time, A, enter a healthcare facility where medical aid was provided to a worker, and B, inspect and audit any records of the healthcare facility in respect of Roman numeral 1, scheduled appointments for treatments or services for a worker, or Roman numeral 2, accounting records in respect of treatments or services rendered to a worker. 3, an inspector and any person assisting the inspector shall not inspect or audit any record under subsection 2, except A, for the purpose of enabling the commission to comply with its obligations under subsection 34.3, and B, in accordance with paragraphs 48A to C of the Health Information Act. 4, subject to subsection 2, nothing in this section authorizes an inspector or any person assisting the inspector to access any records containing personal health information as defined in the Health Information Act. 5, this section only applies to healthcare facility in respect of the provision of treatments or services to a worker, and does not apply to a healthcare facility in respect to in respect of its activities as an employer. Thank you, Mr. Chair.
Right, thank you. The motion is in order. To the motion, Mr. Testart.
Thank you, Mr. Chair. So my colleague, the honourable member from Frame Lake, mentioned some of the concerns in speaking to the last motion that was moved, and they're shared as well with the entire Section 35. The original section was very broad and basically allowed any inspector to enter, I'll read it out, enter a healthcare facility where medical aid was provided to a worker and inspect and audit any records of the healthcare facility in relation to medical aid received by the worker. And that could that would be the entirety of that record, including any personal information that would be protected by the Health Information Act. And again, putting a high priority on the people's rights to privacy and the protections afforded to our citizens through the Health Information Act that would have been negated by this section. It was important that it change. And looking to the Act as it relates to an inspector entering a dwelling place, the Act reads, the occupant or person in charge of the dwelling place consents to an inspector, or the entry or inspection is authorized by a warrant. So to have a dwelling place protected by a warrant provision and a health center not was quite odd upon reflection. So I think what this amendment does is create a similar condition where if an inspector can still access these records if there's a concern of fraud or they need to audit those, but they still have to go through the right channels. And the Health Information Act is paramount in the review of those records. And I think that is a much better balance of privacy and efficiency. And I'm pleased that we were able to work collaboratively with the government on this, and that this will be a consensual amendment. Thank you.
Thank you. Further to the motion? To the motion. Question has been called. All those in favor? All those opposed? The motion is carried. Does the minister concur with this amendment?
Thank you, Mr. Chair. Yes, we do concur with the amendments. And as I said, comments that the members have provided, we will make sure that our counterparts in Nunavut have that information. I'm sure committee is going to share the same comments and concerns with their committee and my counterpart in Nunavut to make sure that we can proceed on this and any questions that do come up when they do their clause-by-clause review. So I just want to give assurance that any information, comments, questions that are being brought forward tonight, we will work with our counterpart to address it. So, yeah, thank you. And concur.
Right, thank you. The minister concurs with the amendment. Thank you, Minister. Committee to Clause 35.1 as amended. Does committee agree? Thank you. Committee, that concludes the clauses. We will now return to the bill number and title. Bill 25, Act to amend the Workers' Compensation Act. Does committee agree?
Agree.
Thank you. The bill as a whole as amended. Does committee agree?
Agreed.
Thank you. Does the committee agree that Bill 25, an act to amend the Workers' Compensation Act, is now ready for consideration in Committee of the Whole as amended? Mr. McNeely.
Thank you, Mr. Chair. I move Bill 25, an act to amend the Workers' Compensation Act, be reported to the Assembly as ready for consideration in the Committee of the Whole as amended and reprinted. Thank you, Mr. Chair.
Thank you. The motion is in order to the motion. Question has been called. All those in favor? All those opposed? Motion carries. Motion is carried. Bill 25, Act to amend the Workers' Compensation Act, will be reported to the Assembly as ready for consideration in Committee of the Whole as amended and reprinted. Thank you, Minister Moses, and thank you to your officials. Do you have any closing remarks?
Thank you, Mr. Chair. Really just to say thank you to the committee for your comments, your questions today on the proposed amendments and motions. I will ensure and let you know that we will be bringing those comments to our counterparts in Nunavut. As I mentioned, I'm sure committee will do the same with the committee over in Nunavut. But we want to thank you for all the work and your staff. I know it was last minute there that we had to make some changes, but coming up with a compromise so that we can move forward on this bill to not only protect our employers and our employees, but also strengthening our workers' protection fund. So just appreciate the efforts. I know it's late on Friday evening, and we guys have been working pretty hard this week, so appreciate making the time so that we can get this piece of legislation passed through. So with that, I just want to say thank you.
All right. Thank you, Minister Moses. And on behalf of committee, certainly we want to say thank you for the collaborative effort that we had between yourself, your staff, and ourselves as a committee, and of course the ongoing communication that we've had with Nunavut and will continue to have hereafter. But with that, we can be adjourned. Thank you.